What's up, everybody? Welcome back. Again, my name is Bria Golder, and I'm here today going to talk a little bit about aggravating and mitigating circumstances when it comes to sentencing. So we talked about criminal sentencing, and I kind of gave you an overview, a big picture overview of what that looks like, how criminal defendants are sentenced, why you may see a number of years that you don't think is fair. A lot of times we don't think it's very fair, but they have to go by a particular system when it comes to sentencing, especially for federal crimes. And the judge takes into account aggravating and mitigating circumstances. So today, that's what we're going to spend our time talking about, is those various aggravating and mitigating circumstances. So let's get right into it. Aggravating circumstances are circumstances that make your case worse. They are circumstances that the judge considers and he says, okay, well, we might need to impose a more harsh sentence because of these various aggravating circumstances. Mitigating circumstances, on the other hand, work in your favor. The judge may look at the mitigating circumstances and say, okay, this defendant has done this, that, and the third. We need to possibly lower his sentence or give a less harsh sentence because of these various mitigating factors. So that's the definition of aggravating and mitigating factors. We're going to run through quite a few aggravating and mitigating factors. And there are two separate categories. So one category is concerning the offender or the person that committed the crime. The other one is concerning the actual activity or the crime itself. So we're going to run through aggravating and mitigating factors for the offender, and then we're going to run through aggravating and mitigating factors for the offense. So let's jump right into it. Aggravating factors can be premeditation. So premeditation is something that you think through before you even commit the crime. The most common premeditated crime that comes to mind is conspiracy, as well as robbery, or conspiracy and robbery, because those two crimes do not merge together, as well as, of course, murder in the first degree. Murder in the first degree has to be premeditated. It has to be thought out. It has to be deliberated before you actually complete that crime. That's what makes it murder in the first degree. You put time into thinking this through, into planning it out, into making sure everything goes well before you actually do it. Same for conspiracy. You know, if I'm planning out a crime, if I'm planning to rob a bank, I know exactly who I'm going to contact and conspire with. I know exactly where the runaway vehicle is going to be parked. I know exactly what bank I'm planning to hit. All of that is premeditation. That's me thinking it through, figuring out a process, figuring out a plan of how I'm going to execute this particular crime, and then attempting to follow through with that crime. That is premeditation. The next aggravating circumstance is a prior criminal record. So if you've done criminal acts before, if you have criminal history, if you've been in the courtroom before, whether for the same criminal issue that you're on trial for now or for something different, a prior criminal record always plays a factor in those aggravating circumstances and how the judge may sentence you. My brother, for example, my blood brother that is closest to me in age, is in prison currently. He's incarcerated, and he has to serve more years because he was found with a gun on him, and he's not allowed to have a gun because he is a felon, which means that he was charged with criminal activity before. But because he was charged with another crime and he had a gun on him, even though this crime was only a low-level felony of driving under the influence, they had a gun found in the vehicle, and so they charged him as a serious violent felon, which upped that charge. Now, I know that my brother doesn't pose a threat to society because he had that gun. I know that my brother is not a bad person, but because of the prior offenses, the court looks at that as an aggravating circumstance, and it's a reason to raise that sentence regardless of who the person is as an individual. They have to look at the facts of the case. They have to say, okay, this is what transpired, and regardless to what that person's intent was, regardless to what they meant by that, they weren't supposed to have a gun, and that's just what it is. And so because of their prior offenses, that offense is taken into account, and the sentence may possibly be raised because of that aggravating circumstance. Another aggravating circumstance is large profits from the offense. So I'm sure this might be before you all's time, but there's a movie called Set It Off. And in Set It Off, they knew that they'd be facing life in prison because of the large amounts of money that they were able to rob from these various banks. So much to the point that Queen Latifah actually let them kill her because she'd rather die than go to prison for that amount of time. But when you commit an offense that is involved with large sums of money or large loss of profits from that offense, then you are facing a possibility of higher prison time because of that aggravating circumstance. Involving others in the offense. So like I said, conspiracy or solicitation. If I come to you and I say, I'll pay you $10,000 to commit this particular crime, or maybe I've even involved innocent, culpable minds, which means that the people did not even know that they were involved in criminal activity, but I maybe brought them in on false pretenses or told them or purported myself to be something that I'm not. And so these people are involved in this criminal activity that they did not know that they were involved in. And a good example of this is maybe a Ponzi scheme or something where we are committing an unlawful activity, but the lower level people that are involved have no idea that the activity is unlawful. And so they are participating in the activity, but they don't know what's going on. And so that can be an aggravating circumstance in my case when I'm looking at sentencing, because I have involved all of these innocent people in my criminal activity. Another aggravating circumstance, and this is a big one in drug crimes, is when you are the ringleader of the group. So if I'm the head honcho, I'm the boss, I am the mastermind, I have thought everything through, and I've got a team of people under me, or I have gotten this whole grand scheme of things together, I might be charged higher because I am the queen pin, I am the queen of the castle, I am the ringleader of this group, I'm the boss, I put it all in play, they couldn't do it without me. And so that could be an aggravating circumstance in my sentencing hearing, because if it weren't for me, this wouldn't have occurred. And so I'm gonna face the bulk of that trouble, even though everybody under me will likely get in trouble too. Me as the ringleader, as the boss, will likely face a higher sentence because of that. Another aggravating circumstance is continuing the offense over time. So if you commit a criminal offense over the course of a couple of days or a couple of months, that's one thing. But if you realize you are successful in committing this offense and you continue to do it over and over and over and over again, you are consistently engaged in criminal activity over the course of years, some people decades, until the government has enough evidence to be able to bring you into trial and find you guilty of that crime, and then in turn sentence you to whatever your punishment may be. Your punishment likely will be worse. Your sentence likely will be higher because you have committed that crime over an amount of time, as opposed to it just being a one and done. I committed this robbery one time and that was it. But if you commit a chain of robberies and they finally catch up with you, of course your sentencing will likely be worse than it would have been if it was just a one-time crime. Okay, now let's talk about some good things. Mitigating factors. Again, remember, mitigating factors help you, aggravating factors hurt you. So let's talk about some mitigating factors that could potentially help you. The first one we'll start out with, excuse me, the first one we'll start out with is a heat of passion crime. So if you don't have the culpable intent or mindset to where you have deliberated and thought it through. Remember, that's an aggravating circumstance. But if you didn't think it through, if somebody just upset you in that moment and so you decided to punch them in the face and now you're found guilty of battery, that's different than if you thought it through and wrote out a plan to run up on this person and intentionally hit them on any particular day. So heat of passion crimes would be a mitigating circumstance where the judge may say, okay, yes, you did commit this crime, but you were under this emotional stress, you were under this pressure, you had this going on that attributed to you committing that crime, and so maybe I'll give you a little leniency in that area. Another word for that heat of passion would be impulsive acts. So you act on impulse based on the surrounding circumstances. Another mitigating factor is remorse. So how do you feel about the harm that you caused to the victim? How do you feel about the harm that you may have caused to society? How do you feel about your actions? Do you feel any remorse? Do you feel like your actions were wrong? Do you feel like the intent of your actions was okay? Do you feel like, you deserve a lesser sentence because you are truly sorry for what happened? That matters. Remorse matters a lot, because at the end of the day, the court's goal is not to throw a lot of people into prison. The court's goal is to make the harmed party whole. They want the harmed party to feel like they are receiving justice. And so if you show some sort of remorse, if you show that you are sorry, if you show that you're getting what you deserve, if you show that you know that you are wrong, that works in your favor, and that is a mitigating circumstance that the court may consider to help lower your sentence a little bit. If you are a young or a first-time offender, that is also a mitigating circumstance. Remember, we talked about aggravating circumstances, and if you are a repeat offender, that's an aggravating circumstance. So of course, if you are a young or a first-time offender, that is a mitigating circumstance. The court will look at you and they will say, okay, this is your first time committing a criminal offense. We're not going to throw the book at you. We're not going to give you the maximum sentence. We're not going to add any aggravating circumstances because this is your first time and we don't want to see you back. So allow this to deter you from committing any more criminal activity, because if you end up back here, it'll be worse. So if it's your first time, you are a first-time offender, a lot of times the court will consider that, and that may be a reason to possibly give you the lower end of what that sentence could potentially be. If you are cooperative with the police, that is also a mitigating factor. So again, always know your rights. Always, always, always know your rights, but that does not give you a license to be rude, to be non-cooperative, to give law enforcement a hard time. You always want to cooperate, especially once you've been charged and you have an attorney fighting by your side. You don't really have much to worry about because the attorney is speaking on your behalf. So you always want to make sure you cooperate, especially with what your attorney is requesting, so that you can be in compliance with the case, so that the case isn't going on longer than it needs to, and also you're in compliance with law enforcement. And it's just a good reflection to the judge that you respect the matter and the seriousness of the matter, and you respect the court as a whole, and you respect their time and your time, so that you're able to get the matter solved and resolved in a proper way. So always make sure that you cooperate with law enforcement, with the judge, with your attorney, to make sure that the case is handled properly and timely. That reflects very well to the judge as to who you are as a person and your character, and hopefully that will help in being one of those mitigating circumstances to land a lesser sentence. Okay, mental and physical disabilities are taken into account as well. So I'm sure you guys may have heard of an insanity plea. So if I have committed murder, but at that time I was found to be insane, out of my mind, schizophrenic, and I could not appreciate the value of that crime. Because in my brain, I didn't even realize that I was committing a crime. I didn't know that what I was doing was wrong. Then that is an insanity plea. So of course, the court will take those things into account. They'll say, okay, well, this person was not in their right mind when they committed this crime. So maybe I'll give them a lower sentence, or maybe as opposed to incarceration, I will put them in a home for mental health. Or maybe I'll put them in a program or a treatment, give them a treatment plan while they're incarcerated so that they can get some help with their mental health to try to be rehabilitated to that of a normal, culpable person. Short life expectancy also plays a role. So I like to think about Bill Cosby. Bill Cosby is not that old. He was not old enough for them to take his life expectancy into account when they sentenced him to all of those years in prison. But if you are getting ready to pass away, if a person is 98 years old and they can possibly sentence them to 20 years, it's like, well, the person is likely going to pass away in prison anyway. And so they take that into account as a mitigating circumstance that may potentially land you a lower sentence because your life expectancy is not that long. And last but not least, another mitigating circumstance is time spent in custody. So if you've already been in jail awaiting trial for 2 or 3 years, that counts towards your sentence. The judge could possibly give you time served, which would knock off years from your overall sentence. So again, my brother, for example, prior to his formal sentencing hearing, he had already been sitting in the county jail for 2 years before he was sentenced to 7 years in prison. And so they gave him that time served, which knocked down his formal sentence in prison to 5 years. And so those are other mitigating circumstances that matter. Now let's talk about mitigating and aggravating circumstances concerning the actual offense. Those were mitigating and aggravating circumstances concerning the offender, the person that committed the crime. But now let's talk about the actual crime itself. So, aggravating circumstances that matter when it comes to the crime itself are questions like, was it a violent crime? The level of violence within the crime definitely matters when it comes to sentencing. Did you brutally beat a person to death? Or did you just punch them, and although you didn't intend for them to die, they had a brain condition that you didn't know about that caused that punch and the stress from that punch to make them pass away? Those are two completely different circumstances, and the aggravation of that circumstance matters. You know, the violence of that situation matters. When you intentionally beat somebody to a pulp, that is a very, very violent situation. That is extremely violent. And so the judge will take that into account when thinking about the offense itself. How violent was the offense? How high or low should I do this sentence based on the violence of the offense that the defendant engaged in? The number of victims matters as well. So, of course, we're hearing a lot about various school shootings. There was a shooting at Greenwood Mall, just different things that are transpiring in our country and even right here in our city with mass shootings. The number of victims 100% matters. You know, if I kill one person as opposed to if I am a serial killer and I've killed 10 people, or if I walk into a mall and I kill 5 people and injure 30, you know, all of that matters. How many people were affected by my behavior? How many people did I harm? That matters, and that is an aggravating circumstance when it comes to the offense committed. Another aggravating circumstance is the need for a deterrent. So sometimes the judge may say, okay, we're going to give you the maximum sentence in this case because we need to show everybody else that we do not play that, basically, is what they're trying to say. We have zero tolerance for this crime that you committed. So even though I could give you 15 years, I'm going to give you 20 because we want to show everybody else we don't play it. Don't do this because you're going to get the maximum sentence. So that is an aggravating factor, is the need to deter others from committing that same crime. Mitigating factors in an offense are the delay in trial. So if for any reason trial is delayed because the jury can't reach a verdict, there was some issue with evidence that was admitted, there was some sort of foul play that happened during the trial, anything, and for any reason the trial was delayed at no fault of the defendant, that is a mitigating circumstance for the offense itself. Another mitigating circumstance is if it is a minor offense. Of course, that is a mitigating circumstance, especially if you are a first-time offender. But right now we're talking about the offense itself. It being a minor offense is a mitigating circumstance. Of course, for minor offenses, your punishment will be a lot lower than it would be for a major offense. So the judge will say, okay, well, this was just a minor offense. This crime, although it is criminal activity, although you are liable, although you were found guilty, it's not that bad in the grand scheme of things. So let's offer you, X amount of years. Let's offer you 3 years as opposed to 10 because your offense was minor. Overall, there are 5 things that the court seeks to do when they impose punishment on a defendant. 1 is rehabilitation. Rehabilitation is when they try to rehabilitate a person to that of a culpable mindset, which we've discussed a little bit already. But if I committed a DUI crime, which means I was driving under the influence, they may try to rehabilitate me to where I don't depend on alcohol. I'm no longer an alcoholic. Or if I have drug issues, they may try to put me in a drug program where I'm able to work through those problems and figure out why I have drug addiction so that I won't have drug addiction any longer. Let's say that I was involved in a domestic relationship, domestic violence, and I was the abuser. They may put me in a domestic violence course to be able to work through my anger and know how to redirect and deal with that instead of engaging in domestic and violent situations. This rehabilitation can be coupled with a incarceration sentence. So it doesn't always mean that they will opt to put you in a rehabilitation program or a treatment program or a series of classes over incarceration. You may do both. You may actually do your treatment program while you are incarcerated, but they do sometimes offer programs for rehabilitation in addition to incarceration or in place of incarceration, depending on the offense. Incapacitation means that you are isolated from the rest of the world. So incapacitation describes, of course, incarceration, whether that be in jail or in prison. Typically, jail incarceration is for crimes where you are going to be locked up for a year or less. Prison is when you are locked up longer than a year for those more serious crimes. But that is incapacitation, where you essentially lose your freedom. Another form of incapacitation would be home detention. Although you have a little bit of freedom, you're still, in the outside world. You are confined to your home or whatever your home base is. So you don't have the freedom to move around like a normal person would if you were free and not on home detention. Another form of incapacitation is probation. So when you have a probation officer who is checking in on you, whether that is to do drug tests occasionally, or if you have to do a daily breathalyzer because you have violated some sort of alcohol or traffic crime having to deal with alcohol. Probation is another form of incapacitation because, again, you have lost some sense of your freedom and you still have to report to somebody that is in control. And if you violate the rules and regulations of your probation, you can end up in jail or prison. There is another form of punishment called restoration. Under restoration, it just essentially seeks to make the other party whole. So for example, fines, like with traffic violations, or if I do something in the community, they may sentence me to community service hours to be able to restore the community and show them that I am a good person again and kind of restore my place in the community. It's kind of like an apology to the community. Another example of restoration would be if I stole an item from a store. The court may order me to pay that store back the amount of money that that item was worth or would have cost if I didn't steal the item. So that's another form of restoration, just kind of making that harmed party whole. Don't get confused with restoration in a criminal sense versus a civil sense. In the civil sense, of course, that's when you're dealing with like lawsuits and things of that nature. In the criminal sense, it'll show up on my criminal record, and I will be charged with theft, for example. But as opposed to me serving a sentence in jail, maybe I'll just have to do some community service or pay a fine to the court or back to the store for that item that I stole from the store. Hopefully this information has been extremely helpful for you today. Aggravating and mitigating circumstances are very, very, very important when thinking about sentencing. Oftentimes, I know we don't think sentencing is fair, and honestly, a lot of times it's not. But judges have to go by the book. They have to go by what's written out, and they have to consider all the factors surrounding the case. And so it's very, 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 very important to always be on your best behavior, especially after you have a criminal indictment, after you've been charged with some sort of criminal activity. You want to reflect yourself in the best light as possible to the judge, to the jury, to your attorney, and to yourself. You want to show up for yourself and for your family because, of course, we need everybody free. That is the best place and the best way to live. That's the best place to be, is to be free, live a life of freedom. And so those aggravating and mitigating circumstances are always good things to keep in mind when considering what a judge may consider when offering a sentence for a criminal defendant. Thank you so much.